I have the time at 8 o'clock, but we're going to stand at ease for just a moment. I talked to some of my members who are still in this wonderful Atlanta traffic. Representative Holcomb, it's good for you to join us. Okay, Chairman Watson is almost here. I can almost see him come through the door. So what we're going to do in getting started, I'm going to lay the groundwork. But first, let's have a quick prayer. If you would bow with me, I'd appreciate it. Dear Heavenly Father, Lord, I thank you for the day and for the springtime of the year. As our farmers all across this great state are getting their fields ready for harvest, I pray for an abundant harvest. I pray for an abundant harvest here, that you will grant us great wisdom as we conduct the business of this great state. I pray for each one that presents today. I pray for, even after this committee meeting and rules, that that you grant us a special measure of wisdom for the bills that come before us. Guard our tongue, that what we say will bring honor and glory to your name. And this I pray. Amen. Okay, just a few ground rules. We're going to, I'll call each of the three resolutions we have today. I will call them individually. We already have a packet, so there's no need to go in depth. And also, I will remind you, although the plaque on the outside of this door says Appropriations 341, the Rules Chairman will be in here just before 9, so we need to be through by at least 10 minutes of 9 to be considerate of the rules process. So we plan to do it thoroughly, but in a brief context. Everyone on this committee has had the packet before them for a week, and each committee member has actually gone through all of the source materials. And so if you could provide an overview and of each case, and we will consider it on its merits. And I will, at this time, recognize Chairman Hogan to present the first resolution.
Thank you, Mr. Chairman and members of the committee. Today I'm here presenting House Resolution 593 for Dennis Arnold Perry. He is an individual that was wrongly convicted over 20-something years or 30 years ago. Along with the Georgia Innocent Project, we present Dennis Arnold Perry and the individual to be compensated by House Resolution 593. Mr. Perry was arrested in 2000 and wrongly convicted in 2003 of the 1985 murders of Harold and Thelma Swain of Waverly, Georgia. In July of 2020, after over 20 years of incarceration, the Superior Court of Glenn County vacated Mr. Perry's conviction and released him from prison. Last year, the same court granted a state motion dismissing the original indictment against Mr. Perry. I can go on, but if you've reviewed the information on it, I don't think I need to move on with it. That's basically what's happening. We got some people who'd like to speak to it also.
Okay, thank you. If you will, when you come up to speak, if you'll represent who you are and what your role is in this. So if you would come up to the podium, I'd appreciate it.
Yes, sir. Good morning, Mr. Chairman, members of the committee. My name is Philip Green, and I, along with my colleagues at King & Spalding and the Georgia Innocence Project, are proud to represent Mr. Perry and to briefly present a summary of his story to the committee. As Representative Hogan mentioned, Mr. Perry was the victim of a shocking miscarriage of justice. He was convicted of 2 murders that he did not commit. He was convicted 18 years after those murders occurred based on 0 physical evidence and despite the fact that he had a confirmed alibi. Mr. Perry ended up spending 20 and a half years in prison where DNA evidence showed that he did not commit the crimes. The original investigators from the GBI and from the Sheriff's Department concluded and always believed that he could not have committed those murders based on his alibi, and the current Brunswick Circuit District Attorney and the GBI also do not believe that he committed the crimes. So given all of that, how did we get here? How did an innocent man spend the prime of his life in prison, where he lost his freedom, his home, his savings, and worse yet, where he spent years suffering the loss of several close family members, including his parents? And in this case, the answer, unfortunately, is straightforward, and it is chilling. We're here because officials that were charged and empowered by the state of Georgia to uphold and enforce the law abandoned the concept of justice and did whatever it took to frame and convict an innocent man, all to resolve what were at that time 15-year-old murders that were unsolved. The record in this case, as you know, reflects that these officials violated court orders, they've ignored their oaths of office, and they cast aside their legal and ethical obligations. I'm not going to go in depth. I know the committee has the information, but a few top-level examples. Lead prosecutor ignored court orders and refused to disclose that the state's star witness had sought and was ultimately paid a substantial reward for her testimony. That same prosecutor concealed a report showing that another suspect, Donnie Barentine, had confessed to being involved in the murders to a professional investigator brought in by the state. That same prosecutor, more importantly, failed to provide an investigative file to Mr. Perry's lawyers, showing that another suspect, Eric Spar, had bragged to his ex-wife and her family that he had committed the murders, and that Mr. Spar's ex-wife had confirmed to those investigators that the key piece of physical evidence found at the scene of the murders, a unique pair of eyeglasses, implicated Mr. Spar and not Mr. Perry. And the failure to turn over all of that exculpatory evidence was especially significant in this case because mitochondrial DNA testing that was conducted in 2020 showed that Mr. Spar's DNA matched that of 3 hairs found embedded in those unique pair of eyeglasses. The law required that the lead prosecutor for the state fully disclose all of this evidence to Mr. Perry and his counsel, and yet they produced none of it. The misconduct in this case, unfortunately, was not limited to the state's lead prosecutor. The lead law enforcement officer was responsible for arresting and charging Mr. Perry 15 years after these murders occurred, also did whatever he could to try to get a conviction at all cost. When he's hired in 1998, 13 years after the murders occurred, he had a set period of time to solve the murders. And within a few days of being hired, he decided that Mr. Perry was the murderer. And then he set about trying to prove that, set about trying to get a conviction at all cost. He, number one, refused to consult with the original investigators from the GBI and the Sheriff's Department, who had concluded that Mr. Perry was cleared as a suspect. He was assigned a deputy who tried to point out that Mr. Perry had a confirmed and documented alibi. Well, that deputy was dismissed immediately from the investigation. And probably more troubling, the file, the investigative file that had Mr. Perry's documented and confirmed alibi disappeared. It was lost. It was unavailable by the time we got to trial, which, of course, is 18 years after the murders occurred, and therefore the evidence that showed and documented Mr. Perry's alibi was forever lost. And these are just some examples that we have in our submissions of misconduct that occurred on behalf of the state. And the result of this misconduct, unfortunately, was a terrible miscarriage of justice that absolutely wrecked a man's life. And for most people, for many people in this room, that would be the end of the story. But Dennis Perry, if you've read anything about Dennis Perry, he's not like most people. He refused to give up hope, and he refused to turn against his faith in God. He continued while he was in prison to proclaim his innocence, and he remained determined to prove it. As Representative Hogan mentioned, in July of 2020, Chief Judge Stephen Scarlick of the Brunswick Superior Court overturned Mr. Perry's convictions and ordered him released from prison. There was a new district attorney elected in the Brunswick Judicial Circuit, Keith Higgins, who went back to Judge Scarlick and asked that all charges against Mr. Perry be dismissed. And District Attorney Higgins represented to the court that not only did his office believe that Mr. Perry did not commit those crimes, but he had consulted with the GBI, who also did not believe that Mr. Perry committed those crimes, which brings us to why we're here today. I'm confident that there's no amount of money that anybody in this room would take to go through what Dennis Perry went through, 20 and a half years in prison for crimes he didn't commit. But while Mr. Perry is no longer in prison for those crimes that he did not commit, there's nothing that's been done to address or remedy the devastating emotional and psychological and financial damages that Mr. Perry has suffered. So, brief discussion about what that loss was, and we can't cover it all in the brief period of time that we have here. But prior to Mr. Perry's arrest, he was a hardworking and a productive member of society. He'd never been charged or accused of being involved in any violent criminal behavior or anything like that. He was, at the time, a 38-year-old man. He was a hardworking man who was working to build an honest life with his first wife. He earned a good living at the time. He had a full-time job as a construction foreman. They had their own home on 2.5 acres. They had hopes of starting their own family in that home. Everything changed when he was arrested in January of 2000. Maintaining his innocence, of course, Mr. Perry sold off everything he had. He and his family spent everything they had on their legal fees for his defense. So in the process, he lost his house, he lost his vehicles, he lost his possessions, and ultimately he lost his first marriage. Mr. Perry, of course, lost the prime of his life and his earning years in prison for crimes he did not commit. He and his second wife, Brenda, are now at the age, he's 60, she's 64, where they should be able to start looking forward in the future to a comfortable retirement together, but they can't. They have no savings. They lost everything they had. Mr. Perry lost more than 20 years of prime earning income that he could have saved and invested. And while they're fortunate that Mr. Perry's wife, Brenda's, that her elderly mother has allowed them to convert a garage into a 3-room living space that they can live in, that's not a replacement for having your own home as married adults, something they cannot do because of the financial impact of what he's gone through. In wrapping up, unfortunately, Mr. Perry did not just suffer through the loss of material possessions. He forever lost more than 2 decades of time with his family. And the time that he spent in prison, Mr. Perry's mother died. Then his father died. His stepfather died. And his grandmother, who by all accounts was his best friend, also passed away. He was in prison. He couldn't go to their funerals. He could not properly grieve their loss. And with that type of devastating loss, it'd be human nature to be angry, to be resentful, to lose your faith. Mr. Perry proved the opposite. He is and always has been anchored by his faith in God and his belief that the truth would ultimately prevail, which it has in this case. Mr. Perry was a model inmate. He was a mentor to others. He was described as an exceptional inmate, and while there's no amount of money that could ever compensate him for what he's been through and the loss of his freedom that was taken from him by the state, we can at least try to remedy some of the economic harm that Mr. Perry has suffered and it continues to suffer as a result. Under Georgia law, as it exists today, of course, as we know, this is the process we have right now that affords someone in his position any hope of reasonable compensation. The request that's included in Resolution 593, based on a review and an analysis of the federal compensation statute, that of 37 other states as well, and that review shows that $70,000 for each year incarcerated is an appropriate amount. And that, of course, multiplied by 20 and a half years that Mr. Perry spent in prison forms the basis of the amount in the resolution. Mr. Chairman, members of the committee, thank you very much. We very much appreciate the opportunity to tell at least a summary of the story of Dennis Arnold Perry. And thank you very much for your time. And if you have any questions, I'm certainly happy to answer them on behalf of Mr. Perry.
Thank you so much. Do I have any questions from members of the committee? Any questions for?
I got a statement.
Okay, Ms. Penny.
I think we ought to go after that lead prosecutor and those other people. I don't know where they are now, but they need to be punished.
Okay. Any further questions from the author of the bill? Thank you, sir.
Yes, sir. Thank you, Chairman.
I think Chair Lady Houston had an amendment she wanted to offer.
An amendment. Yeah, I think 60,000. And now I know that's not enough, but I think for what he went through, I mean, I don't think we can pay any less than 60,000.
Okay. Any other comments from members of the committee? Chairman Watson.
Thank you, Mr. Chairman. The 70,000 that was referenced, well, where is that? Is that in statute or is that?
Well, I'll go 70,000, I just thought we'd try to come to
Sorry.
an agreement between us that was, I can go 70,000. If you want to go 70,000, I can go 70,000.
Well, I'm just curious if that's.
I'll let him answer, but no, it's not in our statute. No, it was compiled from a list of other states.
That's exactly right, and thank you for the question, Representative. We do not have, at this point in time, a Georgia statute that provides a framework for the amount that can be recovered. It's a statute that may be considered in the future, or perhaps right now. When we looked at doing an analysis, Mr. Perry was certainly tempted to ask for a whole lot more than what he asked for. What he asked for was what he thought was reasonable based upon a review of both the federal compensation statute and the state compensation statutes from 37 different states, the states that do have that type of law on the books. In doing that analysis across the country, $70,000 is sort of, it's not the same in every state, of course, but it's the essentially the standard amount, the midpoint. Some states have higher. I think Georgia's considered an amount, if it passes a law on this, Georgia's considered an amount up to $100,000 per year, and then prorated, and then tacking on legal fees and attorney's fees for what the wrongfully incarcerated individual went through. We're not, at this point, asking for all of that. All we're asking for is just the basic $70,000 per year times 20 and a half years.
So did that answer your question? So last year, I know I shouldn't say last year, but in previous times when we've done this, I know the number we used was 40. There is nothing on the book. I think there is legislation that has been introduced that pegs it between 50 and 100,000, depending on the circumstances. I think Representative Holcomb, I could speak to that at some later point, but I think there's a bill that has been introduced and might be moving that would address that. But in our history, last year we used 40. So I'm looking for the will of the committee.
What's the number in that piece of legislation? Do you know?
The request here was at 70,000.
The bill that's moving through to.
The bill that's moving through is between 50 and 100,000.
It's a maximum of 100 and a minimum of 50.
What is the will?
It is so hard to put dollars on the value of a life and the time that you have just represented so well to each of us. I think as we have each vacillated over this and firmly believe that there does need to be an even stronger message sent to those who prosecute without fully and thoroughly checking everything that is available, the tools that they have right now to make sure. I do think we need to look between 60 and 70,000, as Chairman Houston has suggested.
Okay. I'm looking for a consensus among the committee.
I'll second the motion on 60 then, if that was a formal motion, Madam Chair.
Okay. Okay. I have a motion that the amount be set on this resolution, House Resolution 583, at 60,000, and we'll calculate that and get that in if that's the will of the committee. All in favor? Say aye.
Aye.
And opposed? We got it. Okay. That is the amendment. That will go on to the full committee. House Resolution, thank you, sir.
Thank you, Chair.
House Resolution 626. Representative Holcomb.
Thank you, Mr. Chairman, members of the committee. I'm here this morning on behalf of Carrie Robinson. I'll start by saying that this wasn't something that I intended to do this year. When this issue was brought to me, I was not immediately receptive. I'm a former prosecutor, and as you all know, I've spent the last 7 years helping our state reform its approach to sexual assault. Mr. Robinson was wrongly convicted of a sexual assault, and he spent 18 years in prison for that. After I was asked to help, I didn't immediately say yes, even though it was so clear that he had been wronged by the system. I did my own due diligence. I called the prosecutor. I called the defense lawyer. I had the individuals from the Georgia Innocence Project pull his case file, and I went through it. And I had to be completely comfortable that what they were telling me was true. And to be candid with you, I'm a little bit embarrassed by that, because I should have just accepted what they were telling me, that Mr. Robinson had gone through a hellish experience. This had been demonstrated to the courts, and he had been released from prison because he did not do it. But even with them representing that to me, I didn't immediately accept it. I had to do my own homework to be convinced that that was true. So I've now considered myself to be extraordinarily fortunate to be doing this and to be advocating on behalf of Mr. Robinson. I've been able to spend time with him and his family, and similarly to what you heard about Mr. Ross, he is an incredible person. I would describe him, and I choose my words carefully, I would describe him as very inspirational. Despite what he's gone through, he doesn't have hatred or anger in his heart. He's somebody who is extremely gratitude that the day that he always believed would come has in fact come, and now he is free. So with that as the construct, let me tell you just a little bit about the details of his case and why I believe that compensation is appropriate. Mr. Robinson was convicted on two things. The sexual assault itself was absolutely horrific. It was multiple perpetrators, and the victim was terribly, terribly hurt. The main perpetrator was somebody known to Mr. Robinson, and candidly, he picked Mr. Robinson and identified him to spare one of his friends. And so there was a cooperative informant who identified Mr. Robinson and blamed him, so that way this individual who participated could spare his friend who actually participated in the rape. At trial, that's not enough for a conviction. GBI testified, and I love the GBI. I do everything I can, and I know all of us do, to support them with funding and resources and everything else. But on this instance, they got it wrong. And what happened was they testified, and I find this to be unbelievable, but the expert testified that I can't do the math, but it's a very, very low probability that it was anybody other than Mr. Robinson. That was the extent of the corroboration. And because of that testimony, Mr. Robinson was convicted, and he spent 18 years in prison for a crime that he did not commit. The state also had another error, which I think is significant and I want to highlight to the committee. You may recall a few years ago we passed legislation to extend the time period that we preserve evidence of DNA. And I helped work on that bill, and one of the things that I said was this legislation will both help identify perpetrators and it will also help exonerate those that did not do it. So here today, I am here to tell you, or to share with you, that this is a case where the person did not do it, and the DNA exonerated that person. But there was a preservation statute at the time, and the evidence was destroyed when it should not have been. that prohibited Mr. Robinson's defense team from being able to have its own additional DNA analysis. Moreover, while going through the court process approximately 10 years ago, the state had 17 other jurisdictions perform testing to see if their own results were consistent with Georgia's. Of that sample of 17, 12 jurisdictions affirmatively found that it was not Mr. Robinson. 4 were inconclusive, and only 1 agreed with the state's position. I've taken graduate level statistics classes. That is an outlier. And ordinarily in outliers, you don't even count it. Instead, what the court said is that is a battle of the experts, and we are not going to get involved in that. So Mr. Robinson suffered. The system failed him. And so, as was stated, there is no compensation that is appropriate. But we can compensate and we can help. And it is imperative that we do so because Mr. Robinson lost the most productive years of his life, where he wasn't able to build his skills, where he wasn't able to build his savings, where he wasn't able to save for his retirement, and nor was he able to contribute to Social Security. He's doing well now. He lives with his sister, Miranda, who is absolutely incredible, and his brother-in-law, David. He has a great support system. He is working at a job that he really enjoys. He's a forklift operator in South Georgia, and he's doing really well. But this compensation will really make a difference to help his life and just give him some security that he has not had and that was deprived to him because he was wrongfully convicted. And finally, let me just talk to you about his release and what ultimately led to his release. Because of advances in DNA testing, in 2018, the GBI changed the system with which it uses DNA evidence. When it was able to retest with this latest technology, it found Mr. Robinson is African American. Its conclusion was, it is 1,800 times more probable, 1,800 times more probable that a random African American on the street committed the crime than him. That's just unbelievable. So with that, the compensation request is for $551,000. And in full transparency to the committee, I want to share with you, and this is in the documents that you've read, Mr. Robinson was convicted of a minor marijuana charge after he was sentenced to prison for the sexual assault. That minor marijuana charge resulted in a 10-year conviction, which is basically the book was thrown at him. And this was without question because he had been convicted for a crime that he did not commit. So in an attempt to be extraordinarily reasonable and conservative, the request deducts the entire time of that other charge. And so what it averages out to, the request that is being made of $551,000 is $30,611. So it's far below what you just recommended if you were to do it based on the 18 years. And so with that, I'd be happy to answer any questions, but there's no doubt in my mind that Mr. Robinson didn't commit the crime. There's no doubt in my mind that he suffered greatly, and the state caused this problem, and as difficult as this is, and I understand that, we have to do what we can to make things right.
Thank you for that. And Representative Holcomb, there's few under the Gold Dome whose word that I hold any closer than yours.
Thank you.
And your testimony, and I actually talked to you outside of this room about this case, and it was egregious, and I'd love to talk to you offline at some point about making sure that we can that we have the guardrails in place going forward, this does not happen. So any questions of Representative Holcomb from members of the committee? Chairman Watson.
Thank you, Mr. Chairman. I want to first thank the representative for bringing this forward. We talked about this in the very beginning, and as the chairman said, trust your wisdom on this, and I know this is what you do for sure. So thank you for doing this. And I don't know that you can be more wrongly convicted than another. So at this time, Mr. Chairman, I'd just like to make the motion that we go with the $60,000 per year.
Okay, that is a recommendation from Chairman Watson. Any further discussion from members of the committee? Okay, all in favor of the amendment to this resolution is championed by Chairman Watson would say aye. Aye. And those opposed? Thank you.
Thank you.
House Resolution 665.
Good morning, Mr. Chairman and members of the committee. I did not think I would be back to see you all, but Ashley
Representative
George-
Hughley, I look forward to seeing you every year, but I don't like to see you in this capacity, but it seems like you're here each time.
I don't like to be in this capacity, and contrary to what people believe, I don't go looking for these cases. But the situation of Ashley Jordan Delbabot was one that I could not avoid. As a matter of fact, they had called my colleague Richard Smith, and Richard Smith told them to come and see me. So, but this case is something that pulls at me because I am a mother. And the worst thing that a mother can face is the loss of a child. And Ashley Jordan Delbabot suffered the loss of a child and also was accused of killing that child. She was accused of malice murder, felony murder, and child abuse. But let me tell you about her story. The circumstances surrounding Ashley Jordan's wrongful conviction and 12 years behind bars for an unfortunate medical situation is nothing short of a tragedy. In the summer of 2007, United States Army Sergeant Ashley Jordan met, began dating, and married Albert Delbabot. They conceived a child, and Ashley ended her military career because she wanted to become a full-time mother. Albert was transferred from Korea to the 4th Army Ranger Battalion School at Fort Benning, Georgia. And so in early March of 2008, the couple moved to Columbus as they were preparing for the arrival of this child. They did all the usual things that you do when you're preparing for a child. They had the baby's room ready, the bassinet, all of the clothes and everything was ready, and then family members were getting ready to come in to visit because of the birth of this child. In the 8th month of her pregnancy, Ashley began leaking amniotic fluid. She went to the hospital and was advised that if the leaking continued, she'd have to have a C-section. On May 29th, Ashley was back at the hospital with contractions. Her blood pressure spiked. She was diagnosed with preeclampsia and was admitted to the hospital pending labor. Later that day, baby Mackenzie was born vaginally with gentle traction deemed necessary to complete the birth. This family spent less than 2 days in the hospital after the delivery, and the parents took home what they believed to be a healthy baby girl on May 31st. However, Mackenzie was not a healthy baby. Mackenzie was drinking very little formula. She had been drinking a couple of ounces. She had been drinking She should have been drinking a couple of ounces every hour. However, for the entire second day, she only drank 3 ounces. There was another problem. Mackenzie's skull grew from 33.5 to 35 centimeters in a single day. That's 10 times what would normally be expected. Mackenzie was substantially asymmetric. The medical examiner would later note that her legs, her lungs, and her kidneys were all different sizes. A lot was going on with Mackenzie. She was not eating well, her legs were different in size, her skull was expanding rapidly, and the nurse noted an anomaly when she was born. But Martin Army Hospital sent her home with her parents. The young parents cared for the child. They did all the usual things that you do with a newborn the first day. They got her ready for bed. They put her in her new bassinet, but around 1 o'clock in the morning, they heard the baby whimper. And they got up to check on the baby to discover that there was a bump on her forehead. Ashley, a frantic mother, called the hospital and they told her to bring the baby back, so they frantically rushed the baby back to the hospital just 12 hours after taking her home. The hospital staff took Mackenzie and began to examine her, taking x-rays and CT scans, and they tried to save the baby. However, just over 2 hours later, Mackenzie was dead. The next day, the Columbus police arrested both Ashley and her husband, Albert, and charged them with murder based on the opinion of the medical examiner, who never looked at the CT scans or checked any medical history, but said the baby died from blunt force trauma, even though there were no marks on the child, no signs of abuse. With no one else to blame, the DA said that both parents had to be responsible. She said there were only 2 people in that room. A year later, the state convicted both parents and sentenced them to life based on the incomplete evidence at trial, and the Supreme Court would later hold that this trial was fundamentally flawed. The Wisconsin Innocence Project got involved in this case, and after several years and several post-trial motions, the Delbabots introduced opinions of 4 exceedingly well-credentialed medical experts that the medical examiner's conclusion, and thus the state's theory of guilt, blunt force trauma, was incontrovertibly wrong. The expert medical evidence adduced after trial demonstrated that Mackenzie's untimely death was the result of a chain of events that began with a vascular insult that occurred during pregnancy, prior to her birth. The vascular insult led to clots that deflected the blood flow to the right side of Mackenzie's brain, which caused its underdevelopment. Her brain weighed only 320 grams, and the normal range should be between 350 and 400 grams. The clots increased pressure inside Mackenzie's head, which led to an abnormal formation of her skull. The clots also led to a hemorrhage in the lower right portion of the brain. Mackenzie's skull then tore during birth, causing a bleed underneath the scalp. That bleeding, combined with the ongoing bleeding from the in utero vascular insult, led to the child's sudden decompensation and death. None of those conditions could have been the result of the blunt force trauma. The Delbadots appealed twice to the Supreme Court, and on the first appeal, the court vacated Judge Smith's order. The court was deeply troubled that the subsequent medical evidence was never presented to a jury. Also, the court expressed concerns about the evidence that the state had adduced at trial, noting that it was barely sufficient to sustain the conviction as it was. On remand, following the first appeal, the judge denied the Delbadots' motion. They again appealed, and this time the Supreme Court reversed their convictions. They said that the DA had illegally argued that her burden to prove guilt in a criminal prosecution was less than what would have been necessary in a civil liability case. She told the court that you don't have to be 90% sure. You don't even have to be 51% sure. in order to hold both these parents responsible and charge them with the murder. The Supreme Court issued an opinion in early 2020. The new DA at the time reviewed the case and agreed that there was reasonable doubt as to their guilt, and he moved not to pursue the case any further. So Ashley Jordan was 24 years old when this happened to her. She was a 24-year-old away from her family and friends because they had just been transferred to Fort Benning, Georgia. She had no community support as she was going through this. At 24 years old, she lost what most would consider everything. She lost her first and only child. She lost her freedom. And as a result of the 12 years incarceration, the marriage did not survive. However, she told me that what got her through was that she held on to her faith. And she focused not only on herself, but she focused outward, and she used her energy to help others while she was incarcerated, and she wanted to fight to make sure that her baby's voice was heard, and the world would know what actually happened to Mackenzie. So today she's 38, and she's undergoing therapy to deal with this tragedy. However, she declares that she's not resentful or bitter, but she wants a chance to rebuild the remnants of her life. She's employed, and as a matter of fact, she got a job within 2 weeks of being released from prison. And of course, you know, she was released with nothing. She works for Anthem Insurance in Columbus, Georgia, and she started as a customer service rep, and now she's been promoted to claims representative. She wanted to come today, but I told her, you got a promotion, you need to stay at your job, and I'll do the best that I can. She's also going to college, and she's studying for a major in health administration. So what she's asking is an opportunity to rebuild her life, and the amount in the resolution is $840,000. It's based on the $70,000 as you talked about before, which is based on what other states are doing in the federal government. With that, I see Mr. Chairman is tapping, and I will yield.
Well, thank you. I didn't mean to tap. I keep looking at my phone and looking to see that the chairman of the rules come through the back door, but thank you for that, Representative Hughley. I'd like to ask if any members of the committee have a question of you. Hearing none, what is Chairman Watson?
Thank you, Mr. Chairman. I couldn't imagine as what this family's gone through. Having two 2-year-olds at home, it's still fresh on my mind of, even though they're the third and fourth, just taking them home and how things can happen. But at this time, Mr. Chairman, I'll make a motion that we do the same on these $60,000 per year.
Okay. Any other comments from members of the committee?
Well, since I'm a mother, I'd like to give her $70,000, but I guess I have to go along with it. But I understand we got to do the same, but I can't imagine blaming a mother for something like that.
Yes, ma'am.
I don't see why we aren't going after these people that withheld evidence and didn't do it. I'm ready to go after them now.
This is a conversation we need to have. Thank you, Madam Chair. Having an amendment, all in favor, would you please say aye? Aye. Okay, that goes on to the full committee. With that, this meeting is adjourned. Thank you.